When is evidence evidence? Pro Se Law 101. Brought to you by Kenneth Chabert at yourlegallagup.com. Your advantage if you're being sued by debt collectors. This one may go into the too obvious to mention category. So pardon me if it does, but sometimes the most obvious things are the hardest to find out. As I was doing the hearsay video, I suddenly wondered whether people know what I mean by the term evidence. Evidence is something you use to try to prove something. I told you it was obvious, but watch on. Your evidence must increase the chance of what you're saying. It doesn't have to prove it cold, just make it somewhat more likely. You mainly need evidence in two showdown type situations. Trial, and this includes trial in front of a judge, jury, arbitrator, or even discussion with a mediator. Arbitrators act like judges, although they usually have less formal rules, and mediators help you decide to settle. They guide the party to some sort of compromise. And if you don't have evidence, the mediator is going to lean on you to give up more. So you need evidence for the showdown. Think of it as ammo. And the other situation is you may need evidence for a motion. A motion is a request to the court to do something. It's really another kind of showdown too. The main kind of motion that uses evidence is a motion for summary judgment. There will be whole videos devoted to that question, so I won't go into that in detail right now. But anyway, you need evidence for a motion for summary judgment. And the rules of evidence for motions for summary judgment are the same as for court, for trial, by and large. Evidence that would be hearsay at trial would be hearsay on a motion and would not be allowed unless there is some sort of exception. Although evidence on a motion is usually not live, it's documentary in some way, or film a lot these days. Whereas evidence at trial will often be mostly by live people testifying. Still, most of the rules are the same, and when I speak of hearsay, I don't just mean at court and trial. I also mean for any situation that calls for evidence. Although again, in the context of a motion out of court or hearsay means that the words don't come from the person making the affidavit. They are not sworn to. For evidence to be considered by a decision maker, it must be admissible. And objection means you don't think it's admissible. If a court decides you're right and the evidence isn't admissible, the court will sustain your objection. If, on the other hand, the judge decides against you, it will overrule your objection and allow the evidence in. It can be a big deal. At trial, you'll object by voice, preferably before the evidence is actually shown to the jury. On a motion, you'll also object, but of course the judge gets to see the evidence anyway. He or she isn't supposed to consider it if it's not admissible. And if the judge does consider it, even though it is inadmissible, that might be a basis for appealing the judgment. But judges are actually pretty good about that. You may not consider this video or anything I say in this or any video as legal advice. I can't give you legal advice, but as a former lawyer, I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallagup.com. Get my litigation manual and forms. If you appreciate this video, please take a second and like it on YouTube, subscribe and friend me on YouTube, as these things will help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors.